Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists and uncertified podcast co-hosts. We split our time about evenly between trial and appellate courts. My wife says that makes us attack librarians. So we attack librarians, try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast helpful, please recommend it to a colleague. And if not, please recommend it to opposing counsel.
And a quick announcement and thank you to our sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse their service. And listeners of our podcast can receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Okay, Jeff, and we're continuing our recap of 2022, some of the best and worst practice tips and follies of 2022. And in episode 64, we brought you our picks for cases with our picks for the most important cases of 22. Today, we're going to review the cases from 22 that we thought had the best tips for advocacy, both briefing and oral argument and civility, avoiding sanctions. We run the gamut. And also what to do and not to do when it comes to briefing and oral argument. Jeff, you want to kick us off on the category of briefing and writing, what to do, what not to do in briefing and writing, some of our best and worst from 2022.
Yeah, I'll kick us off, and thank you so much for starting this list. You did a great job with this list. We're going to start with Singman versus imdb.com from episode 23, and this is a published decision, and the opinion's only 4 paragraphs long. A lawyer who represented himself at trial and again on appeal. His opening brief had a table of authorities with only one entry, and from this, the court found that legal propositions in a brief without a citation to back it up will be ignored. It's a great, as Tim would say, a great tool to add to your toolkit for briefing rules.
That's right. Yeah, and I thought that this case, Jeff, was not really that surprising because, you know, we all should know, those of us appellate practitioners who've read the rules of court, that if you don't include citations to your arguments, they may be ignored. I thought this was interesting because why did the court publish it? Because that was the interesting thing, is that this case was published. It was very, very short. So you can't just say that, well, it's held to its facts. It's because of these unique circumstances. There were no circumstances provided in this opinion. I thought that maybe this published opinion that holds that uncited legal propositions may be ignored could be abused in the future, just for citing routine black letter law. If you don't include a citation for it, is that going to be ignored, do you think, Jeff?
I don't think it's going to be ignored. Look, I think it's obvious the law clerks the research attorneys at the Court of Appeal decided this would be a published decision, obviously, so to be mentioned on this podcast to improve the quality of appellate briefs.
That's right. Okay, let's go to our next one.
All right, the next one is an unpublished decision in Quach versus California Commerce Club. From April 2022. Again, it's unpublished. But it's interesting. Jeff, it suggests.
I think this one later did become published. I think I put in a request for publication, so it was later published.
Nice. Okay, breaking news. This is one of these rare cases where I agree with you, Tim. This case suggested it is unethical to copy arguments from court opinions without attribution, and I agree. It's not a good practice, but the Court of Appeal in a footnote said it would be unethical for a appellate attorney to cut and paste an argument from an opinion without giving any attribution. And I think you had a write-up on this.
Yeah, I did have a write-up on this. I wondered why you would want to copy and paste language from an opinion without citing to it, because I if I recall correctly, this was. Well, I guess it's possible that it was copy and pasted from an unpublished opinion. Maybe that's the reason for not citing to it.
Yeah. That could be.
And I had heard, from a legal conference somewhere that a research attorney had said, you know, when you copy and paste from unpublished opinions just to get around that non-citation rule, we know about it and we don't like it. And I thought, why would you care? If it's a good argument, then follow the argument. If it's not a good argument, then if you don't find it persuasive, then fine, but don't ding me for for borrowing. There's no copyright protection in legal opinions.
That's
All
funny.
right. One of our most fun episodes, Jeff, I thought, was our interview with Ross Guberman in episode 33. Ross is a treasure trove of briefing advice, and there is that was in episode 33. So refer back to the full episode here. But here were some of the highlights that I recalled from our conversation with Ross Guberman. We talked about how all judges have 3 key fears we should try as advocates to try to tap into those fears that judges have. They are the fear of misconstruing a doctrine or statute, the fear of creating new duties, rules, or defenses in their judicial opinions, and the fear of reaching an unfair result or causing harm to a litigant. So try to tap into these fears when you're writing your next appeal. See if you can tap into them and either spark or allay those fears as the needs of your case dictate. Another tip from Ross Guberman is about discussing bad facts with confidence, not out of defensiveness. Judges and coyotes both can smell fear. But unlike with coyotes, you don't want to try to haze a judge, but you definitely don't want to act like you are fearful of certain facts, or and you certainly don't want to just plain ignore bad facts or downplay them. That all looks defensive. Take the bad facts head on and explain why you win anyway. Another tip from our conversation with Ross Guberman: remember, the purpose of legal writing is to help judges organize their thoughts. Briefs are a tool, but aspire to make them tools that are a pleasure to use. So try to give them the information they need, but sometimes they don't like to just this isn't just a toolkit. It's not just hammers and nails. Try to make it a pleasure. If you use a good turn of phrase, try to avoid jokes. Humor is sometimes not well taken in legal writing, but there are still ways that you can make your writing pleasurable to read.
Right.
So we did talk about using clever quotes and flourishes. Remember, business before pleasure. Nail the organization and analysis first. Mastery of style comes later and with great care. That's why Ross reminds writers of the old advice to kill your darlings. Find the line in your brief that gives you the greatest satisfaction when reading it back, and then delete it.
Yeah. You want your brief to you need your brief to stand out, get attention, especially if it's a writ petition. You want to get attention, but I guess you don't want the writer to get the attention. You want the legal issues and arguments to get the attention. It's a fine line.
It is a fine line. What do you think about the kill your darling rule, Jeff? Do you use that? Do you ever find anything when you read it back and say, I really like that line?
I'm hard to satisfy. When I get to the final brief that I'm ready to submit, I still think there's areas that could be fine-tuned. It's the rare day where I look at that, God, I really enjoyed reading that back. I have a very critical eye, and so I don't find many darlings. This is not an issue that I typically have in my briefs.
Yeah. No, I do like writing, and I like aphorisms. I like putting aphorisms, pithy remarks in my writing, and so I try to put my I guess sharper edged aphorisms in my non-legal writing. So if I'm writing essays or book reports or something, I'll put that up on a blog or on LinkedIn or something, and try to scratch that itch there and leave them out of my briefs.
Right.
Okay, and then on episode 51, we had another one of our great conversations with Justice James Lambden, a retired Court of Appeal justice from the First District. I just really love this line that Justice Lambden had describing litigation. He said, litigation is not like preparing for a battle. It's more like going on an expedition, like taking a trip across the mountains and encountering different places where you have to do different things. And the reason I put that in the outline here, Jeff, under briefing and advocacy tips, I thought it was just kind of a great high level type of a way of thinking about your advocacy in general. That everything about what we do in persuasion is like taking a journey. It's like trying to take the judge that you're trying to convince on this journey with you through the facts. It's kind of a metaphor for showing and not telling. you don't need if you're trying to use adjectives in order to bring your judge to your conclusion, you're doing it wrong. You need to take them on the journey with you. You don't get to magically teleport them to the conclusion by way of adjectives and adverbs.
Right.
Another one of Justice Lambdin's tips was have an elevator pitch for your case. If you only have arguments but no theme, you're not ready to sell your case. Again, I thought that was another great tip for advocacy in briefing in general. If you're going into your brief without really knowing what your case is about, maybe you're not ready to put pen to paper yet. You should know the theme of your case before you try to craft your arguments. And maybe abandon themes that were adopted at the trial level and tune them better and switch them if they didn't work at the trial level. That's right. That was a tip that Justice Thompson had for us. We'll come to a recap of his tips as well. And then Justice Lambdin had this bit of wisdom about the vexing problem of what to do about unpublished opinions. We talk, this is one of my hobby horses, Jeff. What do you do when you find that great case on all fours? All the facts are there, the law is there, but it's unpublished. Justice Lambdin says, who cares? The California Court of Appeal is not bound even by published decisions. So even if it was published, it's not like it's going to save the day for you. There's no horizontal stare decisis in the California appellate system. If you find good legal reasoning, whether it's in a published or unpublished opinion, use it. If the good argument comes from a published case, then make the argument and cite it. If the good argument comes from an unpublished case, make the argument, but don't cite it. In either event, it's not the best citation, but the best argument that wins. And Jeff, this reminded me of what one of my favorite quotes, kind of in my I tried to memorize this. I haven't been able to commit it completely to memory yet, but it's Johann Scotus. Authority sometimes proceeds from reason, but reason never from authority. We should not opinion. This was one of the early church fathers. We should not allege the opinions of the holy fathers unless it be necessary thereby to strengthen arguments in the eyes of men who, unskillful in reasoning, yield rather to authority than to reason. I thought that it just reminded me. Justice Lambdin's comment reminded me about this because he says, it's not about the authority. You're not trying to arm wrestle the judge into believing your arguments. You want to persuade them into believing your arguments. Or at the least give them comfort in terms of allaying their fears that at least other people have either in published or unpublished decisions come to the same line of thinking. So the decision maker here would be in good company. Right. Yeah. Okay, and then we also talked with MC Sangaila, our first podcast guest, and also who also made another appearance on episode 60 of the podcast. MC has interviewed over 100 judges and attorneys now on the Portia Project, maybe even more by now. It's been a couple of months. She's distilled the wisdom and experience of women judges, justices, and top attorneys in the nation. And the big idea that MC Sangaila came to after all these interviews is that when writing for a judge, be mindful of the disconnect between lawyers and judges. Advocates are looking for an outcome, but appellate judges are looking for an opinion. They're looking for a way to write that opinion consistent with the law that makes as few innovations as possible. And they're not like us advocates trying to bury opposing counsel. They are trying to do so, write their opinions in a graceful manner. So try to help the judges get to a conclusion that fits comfortably within settled law, and also obviously in a way that helps your client as well. Yeah. And then next up from episode 54, we had our interview with Justice Thompson, retired Justice Thompson, who gave us some advice on writ petitions. If you don't convince the panel in the first paragraph, you've lost. But some justices might be more lenient. That's a practice we follow at this firm, and we've applied it to good results here. On briefing, Justice Thompson advised us to get the basics right, follow the rules of court, explain the trial court's error and how it resulted in prejudice, acknowledge the flaws in your argument, and above all, be true to the record. I remember Justice Thompson, I asked him point blank,
yeah, do justices and the research attorneys ever remember attorneys from this case to the next case who are not true to the record? He said, yep. No elaboration, I guess, necessary.
You do not want to be memorable in that fashion.
Yeah. And then using signposts in briefing, transitions between sentences, paragraphs, and thoughts are the way good writers hold their reader's hand throughout the brief. And the word moreover is a substandard signpost.
Yeah.
So that was from Justice Thompson.
Yeah, that's right. Yeah. Moreover is just another way of saying I'm still talking. Yeah. It's not helpful.
And then,
yeah. Go ahead.
From episode 58, we talked about using pictures, even memes in briefing. We discussed the prayer at football games case in front of the U.S. Supreme Court, where one justice rebutted an argument of another. That prayer was quiet and short and private, with that justice used several powerful photos of a group of players congregating at the 50-yard line. So yeah, sometimes pictures and memes can be provocative.
Yeah, that's right. I know this is a favorite tip of yours, Jeff. Do you have any other? You want to elaborate just a little bit more on your practice of using pictures from the record in your briefs?
I do like to do it. I like to take snippets of either it's a photograph or a key chart or exhibit, and just cut and paste it right in the middle of a brief. It breaks up long arguments and long narratives, and it catches the eye, for better or worse.
Do you like to do it
on a related point
in the discussion section or the introduction? You have a preference?
No, I don't typically do it in the introduction. I'll do it normally in the statement of facts, statement of case, or argument. I was going to say, on a related point, a lot of appellate lawyers don't take advantage of the fact that California rules of court let you attach any 10 pages you want to the end of a brief. And what are the 10 pages that you would most want the Court of Appeal to focus on, whether it's from the record or from an important case? I find it really surprising that most appellate lawyers don't take advantage of those 10 pages and find some picture or excerpt or deposition transcript or something and make it easier for the Court of Appeal justices to see what's important.
Yeah, that is a great tip. And I've been thinking more that it might be good just almost as a rule, unless you have some better idea, to use that 10 pages at the back of your brief to just maybe include I guess whether you're the appellant, including the minute order or the ruling that you're challenging that has the trial court's reasoning that you're challenging on the appeal. I think that's the first thing that the research attorneys and justices are going to want to grab for.
Yeah. I just filed an opening brief where we're challenging the jurisdiction of the Court of Appeal because the other side didn't file a notice of appeal properly, and we use those 10 pages to attach a judgment, an earlier judgment, and a notice of appeal. Those are 10 pages, so the justices can very easily see those jurisdictional foundational documents.
Yeah, that's perfect. All right, in episode 32, we talked with John Derrick, an appellate specialist and appellate mediator, who, as a former publisher, offered this advice to attorneys in their briefs to when they're crafting their outline, that all important outline for structuring your brief. Use a decimal outline format for headings. Like, instead of Roman numeral 1 and then big A and then Arabic 1 and then small a, use 1 and then 1.1 and then 1.2 and so on. What about you, Jeff? Have you tried that yet? I know there is I think it's a minority view that uses the decimal format. It's a little bit easier to put things in context when you just happen to open the brief to a page and you see a number, and you're being unfamiliar with the rest of the outline format. You don't have any idea where you are. But what do you think? Do you like the traditional way or this decimal format?
I can't say I've used it. I would say if you've got nested arguments where you're at the 1.3, 0.7, 0.9 place, you got bigger problems in your brief than how to number it in terms of complexity of arguments. But no, I'm more old school. I use them.
Yeah, I think that's a good idea. Also, I know research attorneys and justices seem to be insisting, the courts are insisting that you bookmark your full brief so that they can find all of your arguments and headings by using the bookmarks panel on the left-hand side of Adobe Acrobat. So maybe that makes it less important to have that kind of absolute type of reference that the decimal outline format would provide. And then another piece of daring advice in formatting your briefs came from Ryan McCarl in episode 24. He had a lot of great writing and briefing advice, but the one I thought was the most daring was to kill those vertical lines on your pleading paper. Now, this is a trial court tip, not a appellate court. If you're using pleading paper in appellate court, then you need to really rethink your life choices. But even in the trial court, Ryan McCarl says there's no reason to have those vertical lines on the left and right hand side of your paper. You do have to have the numbers that pleading paper format does require that you have the numbers so that the judges can cite the page and line numbers. But those extra vertical lines, and especially even if you're including your firm name and address and email address and phone number on in the margins of your paper, that's just creating a lot of visual clutter that makes your reader anxious. So kill all that stuff, Ryan McCarl says. I've tried that on a couple of my briefs. I kind of like it. I haven't adopted it as my official pleading paper format, but I have tried it and I like it.
I got a little anxious just hearing you talk about that. The thought of removing those lines and sticking out like that. So no, thank you. But let me know how it goes for you.
All right, Jeff. You and I both enjoy adopting legal tech, but sometimes you have a real who moved my cheese disposition on certain things.
That's true. That is true.
We also had a really fun conversation with Stephen Love on episode 43. Stephen Love had reviewed a recent book on persuasion trial tips based on science, on scientific studies. And Stefan's conclusion is that the tips were in greater abundance than the science. It's true that there is much interesting science on the limits of human attention. For example, you can get a person to remember a few things, but one too many, and they forget it all. So this was in our review of John Blumberg's book, Persuasion Science for Trial Attorneys. And when Stefan Love and then you and I, Jeff, went back and forth with him during that conversation, the foil for the conversation was trying to decide whether all these great trial persuasion tips were scientifically based or just plain good advice based on common sense. It was all good advice regardless. But some of the tips we discussed were: excessive information can lead to worse, not better, decisions. Juries learn better with pictures. You could have guessed that. But avoid competition for resources. So don't use written word, spoken word, and images all at the same time. It just creates overload and confusion. I thought that was a good advice because I think we see this a lot, Jeff, just in even non-legal presentations, PowerPoint presentations, where people just put up on the screen what they're going to say, and then they also say it to you.
Yeah.
Along similar lines, you should not present all your evidence at trial because it overloads the jury's cognitive capacity. I think this is a tough bit of advice to put into practice, Jeff, because it means you've got 20 pieces of great evidence, but this advice would say, cut out half of them, or how do you know what to cut out? If you got great evidence, don't you want to put it all in? Wouldn't the appellate attorney coming in later say, why didn't you put it all in? Now I don't have this available in my appellate record.
Indeed. It requires a certain trust in the decision-making process, a trust in the jury or the judge. And I suppose with enough experience and a good read of the jury, you could do that. But, and on the point of excessive information leading to worse, not better decisions and limiting this evidence, I wonder from a plaintiff's perspective versus a defense perspective, if some defense strategies might be to have an excess of information and presenting all evidence at trial so the jury just kind of throws their hands up.
That's exactly right. That reminds me of something that Ben Ikuda said during our conversation with him a couple of weeks ago. that if you're the defendant hospital in a med mal case, then confusion and complexity is on your side. You want to bring a lot of experts to talk a lot of jargon and a lot of confusing things, so the jury just throws up their hands and says, "Oh, I'm sure the doctors have this all in hand. They know this better than I do." So know when simplicity plays to your hand and when complexity plays to your hand, and that'll help you decide whether to put in a lot of evidence or try to focus and narrow your case. Another bit of advice that we talked about with Stephen Love: judges who strive to run ruthlessly efficient trials should reconsider. Eliminating downtime actually undermines jurors' ability to process the information. So I've seen this a lot in trials, Jeff, where the judge is mindful of sucking up all the jury's time and doesn't want to use a lot of more breaks than necessary, and wants to keep, done with your witness. Okay, get the next one in here pronto, and let's get started ASAP. But if you're the trial attorney, try to build in a little bit of downtime in between the different segments of your presentation. It'll help the jury process the information they've just been given.
Well, and there's a timing issue there. If you have a big point that's going to be made by a witness, maybe timing it right before the lunch break or when the morning break will happen, so that even if you have one of these judges that ruthlessly runs a schedule, you have a built-in breaks that the jury has time to take in this big aha Perry Mason moment you've had on the stand.
Yeah, that's right. That's right. And if you do have a good checkpoint type of information, something you want to anchor in the jury's mind, maybe put that up on an easel board with butcher paper. Write down the information, and then leave it up there where the jury can see it the rest of the trial.
Yeah, right. As long as your opponent doesn't jump up and down screaming.
Yeah, or they turn it around away from the jury. And then for the same reason, trial attorneys should slow down in their presentations. Don't talk so fast. Use repetition, and even stop talking every now and then. Again, let the jury digest the information you're giving them. All right. So next topic, we covered some. In our interviews this past year, Jeff, we've covered some issues regarding judicial writing. And again, we talked about this subject with Ross Guberman when we talked about tweet-worthy writing in judicial opinions. The trend in judicial opinion writing is toward informal writing, but Ross mentioned a Ninth Circuit opinion. We talked about this, an opinion by Judge Lee, who had a couple of Hamilton references and a reference to The Bachelor, and I think a Matthew McConaughey line. There was also some Star Wars commentator taking some shots at Star Wars in the opinion. And this was all in a case about class actions. So maybe the judge felt that there was a little bit of dry going material, that he would spice it up a little bit. And that prompted the question that we talked about with Ross: what does informality mean in legal writing? Does informality mean dropping a lot of pop culture references and tweet-worthy memorable aphorisms? And if it does, should attorneys imitate this trend toward pop culture references and tweet-worthy writing that we see in judicial opinions? This is kind of a monkey see, monkey do phenomenon we have. If we see incivility and informality in judicial writing, we're going to see it in attorney writing eventually.
Right. Yeah, right. And when justices do it to the loser of the case, does the loser of the case think, well, the case wasn't taken seriously, this was just a writing exercise, and that the justices didn't appreciate that real people and real monetary issues were at stake? And same, I guess, could be said of lawyers who adopt that informal style.
Yeah. Yeah, and I think the takeaway there is that there is a difference between informality in terms of conversational legal writing. I think that's the good kind of informality that we can all adopt safely, and that most judges enjoy more informal legal writing, less stuffy legal writing. We can drop needless jargon and Latin. We don't need to overflow the banks of the English language and start trying out other languages in order to make our points. We can stick with just conversational tone in our legal writing, but we can stop short of cracking jokes and that would be more appropriate for social media. And then also on this subject, Jeff, we covered a Second Amendment decision in McDougall versus County of Ventura. This was back in episode 26. We also, I think that's the episode we talked with Sean Brady. And, Jeff, you and I kind of agreed at the time about Judge Van Dyke's tone, we'll call it, or the tack he took in his majority and concurring opinion, I think it was, where he anticipated there would be an en banc review, so he wrote his own dissent in his concurring opinion, and after we talked with Sean Brady, who had mentioned that there's some weird things going on with some of our Second Amendment jurisprudence, and if you feel that as Judge Van Dyke obviously did, that there was something amiss going on, and it needs more attention, then maybe the way he went about it was certainly successful at garnering attention into this kind of deviation of precedent on Second Amendment. And so both you and I kind of thought, well, maybe there's something to it. If it's getting results in terms of garnering attention to an important issue, maybe we have to call that a success. Do we still agree with Judge Van Dyke's tack in the McDougall versus Ventura decision?
Well, let me say more broadly that I think the ability of a appellate justice or federal appellate judge to issue a dissent is one of the most important things that a judge can do. And it gets attention on issues that need attention. And so, yeah, I still agree. Yeah,
I do. I guess I do too. It was we were just recapping our conversation with Ross Guberman about kind of this monkey see, monkey do problem. I wouldn't want there to be too much imitation of Judge Van Dyke's, we'll call it a derisive tone toward his colleagues. And I think most attorneys would know that that's not the appropriate tone to take toward judges, even if judges sometimes will take shots at each other. All right, let's move on to tips about oral argument, effective advocacy in oral argument on appeal. And we talked with we talked with Myron Moskovitz. I don't remember if this came up during our conversation with Myron or if we just shared this during one of the tidbits of our episode. But Myron Moskovitz has talked about the futility of oral arguments on appeal. Myron observes how seldom oral argument affects the ultimate outcome and how tentatives or focus letters can improve the system. He also talks about how the refusal to give tentatives or focus letters has become inexplicable. Myron says, come on, how many of us are quick enough on our feet to come up with a persuasive rebuttal to a new twist we've never seen before, right on the spot and no prior thought about it, with three robes staring at you, waiting to see if you can talk them out of a position they've already decided to take in their written opinion, end quote. I think that's a pretty strong case to be made for focus letters.
Yeah, I got to say the most surprising thing about doing this podcast with you and interviewing retired justices is what a wide variety of opinions there are out there about the utility of oral argument. We've heard some appellate justices say, yeah, it really doesn't make that big a difference in most of the cases. And we've heard some say, yep, everyone's important. You just never know when that's the argument that's going to matter. It's been surprising.
Yeah, I have myself flip-flopped on that. I've gone from waiving a couple of oral arguments after getting instruction from my client to after talking with Justice Thompson, we'll cover this in just a moment, who says never waive oral argument because it makes us judges on the panels think you must not really believe in your case.
Yeah.
All right, and related to this point about oral argument, MC Sangaila had this great advice. Justices want to know how to write the opinion. So take a breath and stop trying to win for just a minute and help the judge see how it can be written in an actual appellate opinion. That was from our discussion in episode 60. And then the prior The prior point about the futility of oral argument, unless you have a focus letter, that came from episode 34. Okay.
Right.
Jeff, you want to share Justice Thompson's tips about oral argument and writ relief? Yeah, his points about oral argument.
Yeah, he he said never waive. I don't know. I would put an asterisk next to that strategy, but he says never waive oral argument. At least show up and offer to answer questions. I have to say, at least when I was paid appointed counsel in criminal cases, there would be times where I would waive, or when I had an elderly client and I wanted to move things along. So there are exceptions to that rule, but I will say this: as a respondent, I never want to waive oral argument because the appellant always got the final word in the reply brief, and I really want to have the final word. And as the appellant, even if everything's been briefed already, the ability to tell the justices why, to make policy arguments, not just that there was a mistake and that there was prejudice, but why the court should care. So I tend to agree, never waive in general, with some exceptions. And he also offered up on appellate strategies that re-arguing the same theory that lost at trial might be a doomed strategy, and early on identifying what that theme was and maybe making adjustments on the fly.
Yeah, I think that was a very strong takeaway and very strong sales pitch for us appellate attorneys for why the trial attorney maybe should consider handing off the reins to an appellate attorney, or at least getting a second set of eyes on their case.
Yeah. He also, set up our oral argument catch-22. If the argument wasn't in your brief, why wasn't it in your brief, and why are you going to argue it for the first time in oral argument? And if the argument was in your brief, well, why are you simply repeating yourself? And this is at the heart of what Justice Thompson called the perennial question about giving an effective oral argument. And Justice Thompson provides a solution: identify the real crux of the case, try to present it as in a slightly different way, putting a slightly different spin, perhaps to disarm the panel. And, again, I would say getting into the policy arguments, or maybe as Ross Guberman talks about, tapping into those three fears, either putting the fear in or allaying the appellate justice's fears, depending on where you are in the case.
Yeah. And what do you think, Jeff, about during oral argument, going ahead and just taking on your opponent's strongest arguments or strongest facts? You've presumably you already done that in the briefs, but if you think you can do it with confidence at the oral argument, that might be even more powerful.
It's not something I've ever done, but boy, maybe that's something I should add to my kit in terms of prepare for oral argument.
Yeah.
And finally, Justice Thompson said, don't regurgitate and don't take the other extreme and come up with a brand new theory of the case. Don't simply repeat what's in your briefs, and don't come up with a brand new theory of the case on the fly in the middle of oral argument. It doesn't work out well.
Yeah, that's a good bookend to his two comments about a theory of the case. Don't use the same failed theory of the case that you used at trial and that didn't work. And also don't come up with a brand new theory of case at oral argument. Make sure to expound on that new theory in your briefing. All right. Myron Moskowitz had one other oral argument tip. He's a font of wisdom for appellate advocacy, but here is another bit of oral argument advice from Myron Moskowitz. Here's Moskowitz's theory about when you should start preparing for oral argument. Is it after your reply brief? Is it a week before oral argument? Myron says you should know what your oral argument theme is before you even draft your reply brief. Not after your reply brief. After is too late. The reply brief, Myron says, is so crucial because it's the last thing the justices will read. And even for some jurists, it might even be the first thing they read. But he thinks it's probably the most important part of your briefing. So you should be able to anticipate where the panel is, what the panel is thinking before you go into that reply brief, and craft your oral argument as kind of a bookend to what you're putting in that all-important reply brief. So if you haven't been able to guess what the justices are thinking by the time you write your reply brief, then you're certainly going to be too late by the time you sit down and start writing out your notes for oral argument.
Right. Yeah.
Let's see. And MC
And
Sangaila.
We
Sorry, go ahead, Jeff.
Go ahead.
We're getting a little bit of a lag in our connection. Hopefully it's coming through okay.
Oh, okay. MC Sangalia, in our second visit with her, talked about how appellate judges look at oral argument as another part of their process in preparing to make the decision. And we shouldn't look at oral argument as just an isolated 30 or 60 minutes. That's not how the panel sees it. It's really the final stage in the drafting of the opinion. I thought it was a helpful way of looking at it. And Justice Lambden gave us advice about.
Jeff, when MC Sangaila related that, I don't remember if it was before or after I read something similar that Justice Bedsworth wrote in his column about how important oral argument is for his preparation of the case. He was actually making this point in his pitch that attorneys waive more oral arguments, but it had the opposite effect for me because he related how much time and concentration he spends in advance of oral argument, so he can think, what questions do I need to write? What are the key questions do I need to ask? And what are the key issues that are going to drive the opinion here? So that oral argument is important for the justices. They're preparing for it just as you are. And in a lot of ways, they're preparing for it even more in a focused way because they're getting ready to write their opinion at the same time.
Yeah. And then returning to some of the points raised by Justice Lambden in our interview with him, he said, even more than being buried alive, Justice Lambden said attorneys are terrified of missing an argument, and that is why attorneys tend to indulge the temptation to be over-inclusive in their arguments. But he says making too many arguments comes at the cost of credibility. If the attorney's just running the loop again, the bench is more likely to tune out. We always notice, Justice Lambden recalled from his time on the Court of Appeal, when an attorney told the court which argument to focus on. Excuse me, when an attorney focused. I am getting some weird feedback, Tim. Are you getting a weird noise in your?
You could have just gotten the fire truck siren that came by my office.
No, I'm having some internet issues. Let me hopefully Taylor can edit some of this out.
Yeah.
Because I'm not even sure you could hear me. But let's take it from the top. But making too many arguments comes at the cost of credibility. If the attorney is just running the loop again, the bench is more likely to tune out. We always notice, Justice Lamb recalled from his time on the Court of Appeal, when an attorney told a court which argument to focus on. You'll show courage if you acknowledge a certain argument is not your strongest, and you'll earn credibility when you pivot to the argument that is your strongest.
Yeah, this really speaks to the need for experience and confidence. Both, earlier we talked about how important it is, if you're the trial attorney, not to bombard your jury with every scrap of evidence that you may have, and that's going to take skill and experience and confidence on the trial attorney's part to know, I think I've already gotten well over the line. I don't need to keep going because then I'll just start overtaxing the jury's ability to process this. And the same thing happens on appeal. I think if you start repeating yourself or saying the same argument in different ways or making too many arguments, it undermines your confidence in your main argument. So I think it takes skill and experience and confidence on the part of the appellate attorney to know when enough is enough.
Yeah. And then let's turn to the final area of tips, summing up last year's episode, and that's in the area of civility and sanctions. We talked about a case involving almost $25,000 in sanctions. Case of Clarity Consulting LLC versus it's from April of 2022. We covered that in episode 31 of the podcast, and the Clarity Court offered a PSA quoting an earlier case on behalf of appellate attorneys everywhere. It said, "Trial attorneys who prosecute their own appeals may have tunnel vision, having tried the case themselves of the merits of the They lose objectivity and would be well bar schooled in appellate practice. That is a great case. Every appellate lawyer aware of and cite to.
Okay. I should put up my thing here. Note to lost my thing. Note to Tayer, our editor. Can you back up before Jeff started talking about civility and sanctions? Probably just about 1 minute ago, we started having some audio issues. So let's take up the civility and sanctions topic from here. All right, and turning to our final topic of civility and sanctions in appellate practice. Our first case that we wanted to recap was Clarity Co. Consulting versus Gabriel. That was an April 2022 decision that we talked about back. I don't have the episode handy here, but we covered this case dealing with $25,000 in sanctions, which was talked about quite a bit earlier in 2022. We talked about this in episode 31. The Clarity Court offered this public service announcement on behalf of appellate attorneys everywhere. Quote, trial attorneys who prosecute their own appeals may have tunnel vision. Having tried the case themselves, they become convinced of the merits of their cause. They may lose objectivity and would be well served by consulting and taking the advice of disinterested members of the bar schooled in appellate practice. And that's quoting from another case, but Clarity Co. Consulting is a published decision well worth bookmarking for the issue of sanctions that can occur on appeal, and the wisdom in consulting appellate counsel before going forward. Another case involving an admonition of counsel for making uncivil accusations in his appellate briefs. Sometimes judges don't get your arguments, and that can be frustrating, but don't lose your cool. The Court of Appeal in Shaw versus Fidelity National Title Insurance from December of 2022 admonished counsel for impugning the trial court and opposing counsel in the appellate briefs. The appellate's attorney had said that the trial court refuses to learn the law. The trial court misrepresents the law and knowingly errs to achieve a preconceived outcome. And also, in what perhaps the most colorful turn of phrase, the MSJ proceedings, appellate counsel said, was a magical mystery trial. And finally, the counsel accused the trial court of duplicity. And not to be left out, opposing counsel.
Was that was that a darling trial? The trial judge should have taken out of his writing that referenced the magical musical mystery tour.
Yeah, that is a maybe a fun turn of phrase in another context, but it was simply off-putting in this one. In a legal brief, I think this was a darling that ought to have been killed before hitting the file button. Let's see. The Court of Appeal admonished, though did not sanction, counsel for the diversion from the rules of civility. Quote, such bombastic ad hominem attacks have no place in an appellate brief and are potentially contemptuous and sanctionable behavior, end quote. I've never seen this tack work in appellate courts, Jeff. A counsel may be admonished for using bombast and adverbs to excess, but worst of all, you have lost all hope of persuading your panel. Shaw was unpublished, but relied on published authority. So if you're looking for a citation, check out the Shaw case for that authority. And then finally, I wanted to cover the McQueen versus Wong case from back in March 2022. This case was interesting because appellate sanctions were imposed, but not necessarily because of any improper activity that occurred in the appellate court. The appellate court in that case, if you recall, Jeff, pointed to gamesmanship that the appellant had perpetrated in the trial court. So the appellate sanctions were for trial court misconduct. The appellate arguments here were not sanctionable by themselves, and I thought this was interesting. So don't watch be mindful of your conduct, because it can come back to haunt you. Even if not in trial court sanctions, later on, it can haunt you on the appeal.
Right. You want to take a stab at covering some recent tidbits, Tim? Should I start? See how it goes?
Yeah, give it a shot. See if our audio connection holds up.
All right. So, Tim, imagine you have the privilege of arguing before the U.S. Supreme Court one day, and instead of making the arguments and saying the things that come to your mind, you simply repeat the words and phrases whispered into your ear through AI technology. That is the improbable and provocative proposition made by a company called Do Not Pay. It's offered to pay $1 million to an attorney willing to sneak an AirPod through court security and parrot AI arguments to the United States Supreme Court. Did you see that tweet today?
I did see that when you shared it with me, Jeff, and I saw someone's response. How do you propose getting your iPhone and your AirPods through the Supreme Court checkpoints? They don't allow you to take your cell phones into the courtroom there.
You have to be very creative in your hiding. That was one interesting story. It's a little bit of clickbait because that same company is in the news for having a AI-powered advice in a actual trial proceeding. Not the U.S. Supreme Court, but a trial proceeding that had made some headlines. So that was one news story I wanted to share with our audience. Second news story I wanted to share was that a judge in San Francisco denied an injunction from some folks who are alumni and descendants of Mr. Hastings, who used to be the namesake of the law school up there at Berkeley. I had no idea there were legal proceedings to stop the name change from happening. I guess there's legislation that has renamed the school to the University of California College of the Law, San Francisco. And the injunction was denied by a judge up there, but I suspect an appeal will follow.
Yeah, that's an interesting development there. I wonder how long before Yale has to change its name. Named after Elihu Yale, a very prominent slaveholder back in the day.
I wouldn't hold your breath on that one.
But only because it's not an Ivy League school. Only the non-Ivy Leaguers need to change their names.
Yeah, I suppose.
All right. All right. Well, that's going to wrap up this episode. Again, we want to thank Casetext for sponsoring the podcast. Each week when we include links, we use Casetext for those links. And listeners of the podcast can find a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP. And if you have suggestions for future episodes, please email us at info@calpodcast.com. And as we go forward in 2023, look for more tips on how to lay the groundwork for an appeal and get more trial and appellate insight.
That's right. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.